So what are the requirements for judicial review under the Human Rights Act 1998, and what challenges do applicants face? The core issue here is whether individuals can actually bring a judicial review claim under the Human Rights Act 1998 to challenge decisions of public authorities that violate their convention rights. And, what are the legal requirements and practical challenges in doing so? Under the Human Rights Act 1998, individuals can challenge public authority decisions where there is a breach of a right protected by the European Convention on Human Rights. The key requirements are, first, public authority under Section 6, subsection 1 of the HRA, the body must be performing a public function. Then victim status under Section 7, subsection 1 of the HRA, the applicant must be a victim of the unlawful act, which has the same meaning as under Article 34 of the ECHR. Next, there must be a breach of a convention right under Section 6 of the HRA. A public authority must not act in a way that's incompatible with a convention right unless required by primary legislation. Time limits are also important. Under Section 7, subsection 5 of the HRA, judicial review must be brought within 1 year, although Civil Procedure Rule 54.5 still applies. So it must be brought promptly and within 3 months. And finally, remedies under Section 8 of the HRA courts can grant just and appropriate remedies, including damages. But these are discretionary and honestly quite limited. Public authority is a crucial concept here. The respondent must be a core or hybrid public authority. Local councils, NHS trusts, police and government departments are clearly core authorities. However, private bodies performing public functions, such as housing associations or schools, may qualify as hybrid authorities. But, courts are generally reluctant to extend this label too broadly, as seen in the case of YL v Birmingham City Council from 2007. So, when it comes to applying, the applicant must be personally and directly affected. That means you really have to show how the issue impacts you specifically. Interest groups or general members of the public can't make a claim, even if the issue has a wide impact on society as a whole. Now, the grounds for judicial review under the Human Rights Act are pretty clear. The court has to assess whether the public authority's action is incompatible with a convention right. For example, Article 8 covers the right to private and family life, which often comes up in housing disputes. Article 6 is about the right to a fair hearing, especially relevant in tribunal decisions. And Article 3 deals with inhuman or degrading treatment, which can be a concern in care or detention settings. Applicants, honestly, face quite a few challenges. The standing or victim status test is actually narrower than what you'd find for common law judicial review. Figuring out whether a hybrid body is performing a public function can be pretty uncertain. Plus, the time limits under the Civil Procedure Rules, 3 months, are much stricter than the Human Rights Act's 1 year. Remedies are mostly discretionary and courts rarely award damages. There are also defenses under Section 6, subsection 2. Authorities aren't liable if they're acting under incompatible primary legislation, which really limits the court's power to just making a declaration of incompatibility under Section 4 of the Human Rights Act. Judicial review under the Human Rights Act, provides an essential route for challenging breaches of human rights by public bodies, but applicants do face significant procedural and substantive challenges, especially when it comes to proving victim status, meeting strict deadlines, and actually obtaining effective remedies. While the Human Rights Act definitely enhances accountability, it does have its limitations, particularly when primary legislation is at fault. In those cases, courts can only issue non-binding declarations which, might not always lead to real change.